Good afternoon and good morning, everyone who's joined us, wherever you are in the world. It's good to have you all with us. Apologies for being a couple of minutes late, but I think we are ready to kick off. I'm Mike Currie. I'm a partner director at Primerio in South Africa, and I'm very pleased to be joined by my fellow colleagues. I'll start with Mweshi and Bunda from Mweshi, Bunda and Associates, our Primerio in-country partner in Zambia. We're Cris, Mwebesa, who is our in-country partner in Tanzania from Mwebesa Law, and we've got Hyacinthe, Fansi, our in-country partner in Cameroon from Ngassam, Fansi, Djeutchou, and Mben. All three of you very experienced antitrust and merger control practitioners, not only in your own national regions, or own national territory, but also in the region. For those who followed Primerio and our thought leadership or advocacy initiatives, I think you would have known that we do a lot of policy work, a lot of thought leadership work in trying to develop, excuse me, best practice in antitrust merger control across the African region. We dedicate a lot of time and effort to do that, and I think we've made a meaningful contribution. But this webinar and this session is got a slightly different focus. The inspiration for it was to be a far more pragmatic session, and it really stems from, I think, if one looks at how merger control has developed across Africa in the last 4 to 5 years, there's a very clear shift, an increase in the number of agencies that have adopted merger control laws or antitrust laws more generally beyond just merger control. The sophistication of the rules and the application of those rules have developed quite somewhat, and I think quite importantly for both local and international colleagues, anyone who's involved in antitrust compliance and enforcement and merger control, what is certainly noteworthy is the level of interaction between African antitrust agencies, both on the continent and internationally. They are represented on the major speaking platforms, on the speaking circuits, whether it's IBA, ABA, OECD, and a multiple of other international platforms. There's obviously the African Competition Forum, which is particularly active, and that does change a lot of the sort of perhaps the risk or the degree of attention that our antitrust practitioners place on various African jurisdictions. When we typically get confronted with multi-jurisdictional filings and, which jurisdictions are filings going to be triggered, which ones should we actually go and notify in, what are the risks, what are the detection risks, are there good arguments to avoid filings, what degree of confidence do we have that we'll get an approval in a relatively expeditious time period for a non-contentious transaction. Those sort of general questions, we deal with a lot. And if you sort of see our advice, and I think collectively we'll share that. If you look at our analysis as Primerio over the last 4 or 5 years, that's just changed considerably to jurisdictions which perhaps previously wouldn't have been flagged as sort of high risk or key jurisdictions. I think there's a lot more active jurisdictions on the African continent now. Then you throw the regional blocks into the mix, and that only exacerbates. It exacerbates not only because it's a new regime, but because the detection risk increases considerably. And so the whole approach of, and really this is sort of multi-jurisdictional filings in mind, the whole strategy, the whole approach, what you need to be mindful of, which jurisdictions you need to target, what are your time periods, all of those kind of questions, it changes the dynamic quite a bit. So that's why I'm very pleased to be joined by Mweshi, Cris, and Hyacinthe, and between the four of us to give all of you who've dialed in a little bit of a sense about what's going on the ground. There's a lot that is published, perhaps. I think all of us collectively have a lot of experience with filings in these jurisdictions, and can, we'll try and share what we can in a highlights package. Best practice, things to watch out for, and just anything that we think antitrust practitioners, particularly with a merger control focus, ought to be ought to be mindful of. So with that in mind, I'll start. Hyacinthe, I'm going to start with you. You know, you're based in Cameroon, got a lot of experience, not only before the Cameroon Authority, but in particular CEMAC. I want to start with CEMAC first. We'll get to Cameroon in a bit, but start with CEMAC first. Can you give us sort of our audience members a bit of a snapshot of what's going on in your experience, more recent experience in terms of merger control before CEMAC?
Hello, Mike. Thank you for having me. Hello to the audience and my co-panelist. Well, CEMAC merger control has evolved in the last year from a basic framework to a more robust, although still developing system with recent reforms enhancing transparency and streamlining processes. Key development includes, for example, the introduction of mandatory notification for mergers meeting specific thresholds, a more structured review process, and the potential for substantial penalties for non-compliance. However, while the authority is now better equipped to handle complex transactions, some areas, particularly in terms of enforcement and case law, remain underdeveloped, though the trend is for stricter compliance. Another major challenge which the CEMAC region has been facing is the potentially high filing fees, which are capped at approximately 17 million USD. I believe this is one of the most expensive filing fees in the world, actually. And these have faced a business pushback and may need further future review. Thank you, Mike.
One of the queries that we constantly deal with are what types of transactions are caught within the CEMAC jurisdictional test threshold. It's a pretty low threshold, right? Can you maybe give the audience an overview of, you know, foreign-to-foreign transactions, for example, or transactions where both parties are principally active in the same member state? A lot of those transactions do get triggered, but if you could say some of those thresholds out, then that'd be quite useful.
Yes. The threshold in terms of CEMAC merger notification, the threshold are either in terms of turnover or market share. It's a combination. It's either the one or the other or both at the same time. In terms of turnover, the triggering requirement, it's 10 billion franc CFA, which can roughly be converted into, I believe, something around $1 million USD or so, and a market share of 30% in the concerned market. What type of transaction are actually caught by the Competition Act in the CEMAC region? The Competition Act uses the broad term of concentration, which englobes either acquisition, merger, that is combination between firms, and joint ventures. Basically, this is what I could say around concerning what type of transaction are caught by the regulation and then the threshold. Another specification with the CEMAC is that normally there is an additional requirement which provide that a transaction should be having should be potentially having an effect in at least 2 member states. But that additional requirement is a standalone requirement, because actually you can have a transaction where the merging parties achieve the threshold in terms of turnover, for example, that is above 10 billion franc CFA, and then that transaction will actually be notifiable to the CEMAC Commission, even though the transaction shall be implemented only in 1 member state. Thank you, Mike.
And so, assuming you're emerging parties, you've gotten over the shock of the filing fee. You've established that there's no way around avoiding the jurisdictional test. What degree of comfort or confidence do you have of getting an approval relatively expeditiously? What timelines are we looking at? What are the factors that might throw that timeline out from what parties might expect to receive? Assuming
Yes.
assuming a non-contentious transaction.
Yes, but generally, the commission has their commission, the CEMAC commission, which is actually the regulator. I will refer to the regulator as the commission for the purpose of this webinar. The commission has a 6-month window for a decision after immediate notification is received. Parties to a non-contentious transaction can expect the process to be expeditious, but the actual timeline depends on the accuracy and completeness of the filing, as any delays in providing information, for example, would pause the clock. For a smooth and prompt approval, it is crucial to provide complete and accurate filings to the Commission. And then in practice, a non-contentious filing might take up to 3 months to get an approval from the Commission. In practice, in general.
Yeah.
But for more complex transactions, this might take a longer period.
Yeah, which seems to be quite an improvement from a few years back, and I think that goes to your point about the agency being exactly, but more of capacity building internally to handle and process mergers.
Yeah, though there is still a lot of red tape, a lot of paperwork. If you recall from your experience in CEMAC, when you file, you have to submit in 10 copies, either the filing form and any evidence attached to the filing form. It's quite a lot in terms of paperwork, but the Commission has been doing great in improving the way they handle the merger review.
Brilliant. I'm going to hand over to Mweshi. Mweshi, you're based in Zambia and have extensive experience before the COMESA Competition Commission. From a regional agency perspective, the CCC is by far the most or established regional competition agency on the continent, particularly in the last 4 to 5 years, I think under the leadership of Dr. Mwebesa. We've seen a lot more enforcement, not just in merger control, but within the broader unilateral conduct and anti-competitive and consumer practices within the CCC. So I think most of our international antitrust community are relatively familiar with the COMESA regime more broadly. However, there are developments on the horizon. You've been involved in commenting on those developments. I don't think all of it is confidential. It's been well publicized that there's going to be a new regime coming on stream soon. I know you've been intimately involved in that. To the extent you're able to discuss and divulge some of those key developments, I think our audience will be particularly interested in those.
Okay, thanks, Mike, and good afternoon to all the audience members and my fellow presenters. So yeah, the COMESA Competition Commission, which I'll be referring to as the CCC, is going to be implementing amendments to the 2004 regulations. And some of the key features that are coming out of that amendment is, one, they are extending their merger notifications to green ventures. Green joint ventures should be notified. You have issues of digital markets now being subject to merger notifications as long as the thresholds are met. So the threshold tests have largely remained the same, which is regional presence, meeting the financial thresholds, and also just the local presence and all that, which is presence in 2 or more member states. So that has remained the same. The interesting development that I would want to highlight is that there is now a requirement, once the new rules come into force, before the CCC begins its assessment of the notification, it will have to notify the authorities in the member states that are going to be affected by the proposed merger. And this notification will include sharing of confidential information that the parties have shared with the CCC, provided that the member state's authority has regulations or provisions in its law in place to recognize and protect the parties' confidential information. I think one key issue.
Sorry to
Yes,
interrupt you, Mweshi. How robust is that notification envisaged to be? Is it sort of a letter to the other agencies, or is it sort of a mini simplified filing, or is it a copy almost of the filing that you've made to the CCC? Well, sorry, you said in advance of notifying the CCC. Is there any guidance on that?
Not really. I mean, what it says is that they'll give them a notice, and in the notice, they will send through the information that the parties are going to submit to the CCC. So to me, it sounds like it's going to be a mini notification, just sharing the same pack of information that's been provided, unless that authority does not have any safeguarding provisions for confidential information.
Yeah. Sorry, I interrupted you.
Another key feature is, no worries. Another key feature that I think everyone will be interested in is that the new regulations or the amendments are going to provide more clarity in terms of the period when parties are supposed to notify. Currently, it's within a period of 30 days of a decision to merge. But once the regulations are amended, this has been simplified to before implementation. I think that makes it easier for parties to comply without being in breach, because you don't want to start notifying within 30 days of a legally binding agreement before any of the necessary steps for the transaction have been taken. So I think that will be a welcome development. And another issue that will be of relevance is the timeline. So the timeline under the amendments will be revised to 90 days of a complete notification. So that will be all the relevant information, the supporting documents, and the filing fee to trigger the running of the time. And within 90 days, parties are supposed to receive a decision on the notification. However, this is with the caveat that the CCC is going to be empowered by the regulations once amended to seek extensions. These extensions do not have a limitation on the number they can have, but the aggregate period of the extension should not exceed a total period of 90 days. So that's something to watch out for, as well as the introduction of a committee that's responsible for determining whether an extension can be granted to the CCC or not. So the new regulations introduce a committee responsible for determination, that's its name. And that will give the go-ahead in terms of, yes, there's reasons to give an extension for this merger notification. Another issue concerning timelines is that if a party is, the merging parties are requested for additional information by the CCC and they don't provide that information, the CCC is now going to be empowered to stop the clock from running. So the 90 days will stop running until the information requested is provided. So I think that is a very cardinal issue for parties and their advisors to watch out for. Otherwise, the timelines might not be achievable.
Yeah, I mean, on timelines, so there's going to be another dynamic here, right? Which is you're moving from the current regime, which is the 30 days, non-suspensory. So once you notify CCC within the 30 days, parties can actually implement their transaction. Of course, there's some risk that if there are issues, you might be asked to unwind it. But if you're confident that there are no issues and you're in a global transaction and CCC is the last authority whose approval you're waiting for, you can technically close. This new regime is going to change that, right? It's going to be a suspensory regime, which is more in keeping with most antitrust agencies. And is there anything on the transition period, right? If you've got to, well, firstly, when do we expect these regulations to be published? And then secondly, what do parties do in this interim period where you might be filing under the old regime when the new regime kicks in? Is there a formal acknowledgement of some transition period?
Firstly, there is some formal notification. So any rules that are in force before the transition are still going to be respected. And for timelines, I might need you to come in on that in terms of implementation of the new rules coming into force. My understanding is that it's in the first quarter of 2026.
Yeah. Good. Well, that's exciting developments, and we're going to get back to some of the due process points under the CCC, sort of even under the current regime. But then let me head over to Cris.
So basically, any investigations or any merger notifications that will be submitted before the transition period is complete is going to be determined under the current regime.
Yeah, exactly. So get those filings in relatively quickly. Would be the message. Take advantage of the non-suspensory regime if anything turns on that. I should have mentioned to our audience members, please feel free to pop any questions you might have on any one of the regional territories we're covering. Just pop into the chat and we'll try and address that. I should have mentioned that in my introductory remarks. Cris, I'm going to move to you quickly. You have the benefit of being in Tanzania, being a former regulator for and of course now moved to private practice. And you also have the benefit of the East African community having come on stream and accepting merger notifications. Obviously very new. Give the audience a little bit of insight into what the EAC's regime looks like, what you're having considered the regulations, guidance notes, what you anticipate being some of the key challenges in that regime.
Okay. Thanks, Mike, and good afternoon, everyone. First of all, under the new regime, the East African Community Competition Authority enjoys exclusive jurisdiction on all competition and consumer protection matters, including merger control, ones that have cross-border effect within East Africa. And if you are to read the law, which came into force in 2006, only that the regulations came recently, and they actually came into force in November, 1st of November this year. The definition of a merger is an acquisition of shares or a business or part of business or assets, whether inside or outside of East Africa, with an effect of change of control of a business or part of a business or assets within East Africa. Okay, so that is the definition. So a transaction taking place involving parties anywhere in the world, as long as it has an impact on the change of control within East Africa, then it is notifiable. And in terms of the criteria, as I've already said, the transaction has to have a cross-border effect, meaning that two or more partner states are affected by that transaction. Two, a combined asset or a turnover of $35 million. Okay, but they have provided a bit of clarification, I think, which is good, particularly because even for transactions, because they are taking what we call global turnover and assets, so they have provided a proviso to the effect that $20 million of that must be of the combined assets or turnover must be generated within a partner state. And further, if 2/3 of the threshold is generated in a single partner state, then the transaction is not notifiable. In addition to that, in terms of the processes, they have what they call preliminary assessment, where if they feel that the merger is not notifiable, they'll give you a refund of the filing fees, and they'll give you 70% and retain 30%. And in terms of the timelines, we're talking of 120 days. It's not clear whether it is working days or days. And once you lodge your application, it has an effect of, suspending the transaction until after you obtain the approval or otherwise. And the filing fees, they range between $45,000 up to $100,000, depending of where you're falling in. And failure to notify will have two effects. One, the measure will not come into effect, number one. Number two, you might be subject to, penalties. But we do not know what will now happen in practice. But we are expecting a lot of overlapping and a lot of pushback by the national authorities, especially because, for example, a few of the countries have not domesticated the regional law, and as such, the national authorities continue to enjoy exclusive jurisdiction over regulation of markets, including measure control. And there's also a confusion of some almost 6 members of East African Community are also members of COMESA, and 2 members of the East African Community are not members of COMESA. So the effect of that, there will be multiple notifications so as to be compliant. But hopefully, the law will evolve and develop and sort out some of those issues. And there are other countries, for example, Somalia and South Sudan. They do not have the local laws in place. So we do not know how the East African Community Competition Authority will deal with that. But it started being effective from 1st of November this year, and those are some of the issues. But it's progress, in my opinion. It's progress, and the law will keep on developing.
Thanks, Chris. And that $100,000 filing fee is that an outright cap?
Yeah, that's a cap for if your combined asset of turnover is more than $100 million. That's when you pay $100K. So comparatively, particularly in other markets, I think it's not that aggressive, in my opinion. Yeah, and especially because there is also the preliminary assessment, where if the Commission feels that you do not qualify or you do not need to notify, then you get a refund of 70%, and they retain 30%. And the argument around that is that it is retained because they had of the preliminary assessment that they have done.
Yeah, that's pretty advanced, and I think fair way of going about it. Because I think in Hyacinthe, you'll correct me if I'm wrong, but I think in CEMAC, Triple C, Mweshi, and in ECOWAS, I think once you pay the filing fee, that's it. I don't think there's any refunds for those. The one-stop shop issue, it's an issue that's faced all these regional blocks at some point. I know in ECOWAS we're dealing with the fact that Nigeria, the FCCPC Nigeria, doesn't recognize ECOWAS's one-stop shop jurisdiction, and so recently we've made several filings to ECOWAS where we've made parallel filings in Nigeria, and given that Nigeria is one of the largest economies within the ECOWAS region, there is typically, or very often, whenever an ECOWAS filing is triggered, that there is a Nigerian filing triggered, or vice versa. And so we're seeing increasingly dual filings made, which is tough because the FCCPC is also one of the most active national regulators on the continent. Anyone who's followed much of what's going on in Nigeria would have no doubt seen the penalties imposed on BAT and Meta. Those weren't merger control infringements; those were unilateral and consumer protection conduct. But $200 million plus penalties by way of settlement in the case of Meta, and a fine far exceeding that against the $250 million penalty was against BAT settled, and I think the Meta penalty significantly above that, upheld by the tribunal. So a very active jurisdiction, and one which engages very frequently at a COMESA level as well. So in the context of detection risks, you can be relatively assured that a filing that goes into Nigeria will be picked up by ECOWAS or vice versa. And the ECOWAS regime, merger control regime, which is now a year old, so but somewhere in between CEMAC and the EAC, a year old. We've had relatively probably positive experiences. I think generally all our transactions that have gone through have non-contentious transactions have been approved, relatively expeditiously. I think there are several pressure points. One is also the very low threshold for a merger to trigger, or for a merger to trigger the filing requirements. It's less than approximately 5 million USD for two of the parties each, or a combined 20 million USD filing. In ECOWAS, they use units of account. It's got a slightly different exchange rate to the USD, but it's not too far apart. So I just use the USD as a proxy. And then if you look at sort of the regional dimension, both parties could be sort of physically present in the same member state, and then just have some sales out of that member state. And those sales don't even have to be very material, can be relatively nominal sales. But as soon as you have one of the two parties having sales outside of that same member state, you trigger, at least technically, your community dimension test. So there's a very, very low threshold for filings, and that, or at least to meet your regional dimension tests. And likewise, foreign to foreign transactions are also captured. So sales in to two or more ECOWAS member states for a foreign to foreign party would also trigger your filing. That said, I think they've got relatively advanced guidelines in what they're looking at. The forms are quite comprehensive. The one challenge we have with ECOWAS is, and it's a challenge that a couple of agencies have as well, is that your clock only starts once they receive the filing fee in their bank account, and the process and the time between submitting the filing, them assessing the data and the turnover figures and getting confirmation that they're comfortable with those, and then facilitating that transfer, that can take a while. And so that's something one must factor into your time periods, not just your statutory time periods, but the time that it takes between actually getting that clock started. You can add about a month to that process. I think it's largely due to, similar to what we heard from Hyacinthe on CEMAC, a bit of capacity building internally. I think even in the last 12 months, if you see the trajectory and how the trend, things are picking up, things are improving, the response times are quicker. The committee, essentially the EXCO committee who needs to approve the transactions, they meet relatively periodically, probably not often enough. You can have a transaction that's ready for approval, but still take another 4 to 6 weeks to actually get the formal approval, just waiting for a meeting to be constituted. That's a gap which we've tried to point out and see if there are ways to plug that gap. One of the proposals is just to allow the committee to approve by way of round robin approvals, not to have to wait to meet in person in the Gambia to do so. So we hope those suggestions are taken on board. But from a regime perspective, I think they've made good strides. You know, I think there's relatively decent guidance on what types of transactions are captured. There's commentary on joint ventures and how to attribute turnover in the context of joint ventures for purposes of calculating filing fees and thresholds and the like. What triggers control? They don't have a clear test yet on, you know, whether it's material influence or decisive policy when it comes to control. But I think if one looks at the guidelines and their approach to date, generally, I don't think it's too out of kilter. You know, strong veto rights, which really allow you to have some ability to materially influence the direction of the company post merger. I think the test which would be triggered in EU and South Africa and, you know, most of our regional territories we've covered to date would likewise trigger it in ECOWAS. And then, yeah, penalties are quite significant. A minimum penalty for prior implementation or gun jumping, minimum penalty starts at 500,000 units of account, or just a little bit more than $500,000, going up to 10% of the party's member common market turnover or asset value, whichever is highest. So there's a lot to think about and a lot to sort of grapple with in the context of preparing for an ECOWAS filing. But generally, our experience has been pretty good. They've also quite recently imposed their first condition to a merger. That was in the brewery and beverages markets, perhaps more broadly, where the authority found that the parties had a pretty high market share in one of the member states, and ensure that they removed any exclusivity in their distribution arrangements. And so while the decision and the theories of harm are, you know, very, very high level, and I think the authority would be well placed to sort of expand on its decisions and the evidence upon which it relied in its decision making, you know, to arrive at the conclusion that there could be some foreclosure or some anti-competitive concern. There's very little of that in their decision that's published. It's sort of a two-liner saying that there could be some competition concern due to the party's, you know, high market share, and then you have to deduce from the remedy that they imposed that concern was a foreclosure one on distributors across the region. So, and I know, Mweshi, you'll recall, I think from the early days of the CCC, the decisions that were published were also relatively scant with information and the evidence relied on to support the conclusion. That's changed a bit, right? If you look at the decisions, not only again merger control, but other decisions elsewhere, the CCC has certainly made some meaningful progress in providing more comprehensive reasons and analysis. Is that a fair observation?
That is, Mike. They have become more detailed in their analysis. And this analysis is expected to get even more stringent under the amended regulations when they come into force, because now they won't only include the economic effects of the potential merger, but then they'll also extend to public interest considerations. So that is going to be an interesting development to have a look at, to just see exactly how they are going to start analyzing, because the issues that they're going to be considering are what is the effect on employment, competition, effects on small and medium-sized businesses, and issues of innovation, etc. So that will be interesting to see how they're going to evolve over the next few years.
Very, very interesting. I mean, we've been dealing with public interest, those same considerations from a South African perspective for 2 decades, and it's still a highly contentious area. It remains so, notwithstanding that there's now a relatively healthy body of precedent out there to go about quantifying and weighing up public interest considerations and grounds is complex and convoluted and subjective. You put that before a regional body, well, that is going to become a real dynamic, because what's in the public interest for one agent, one member state may be very, very different from another one, right?
Right, very correct. The beauty is parties will be given an opportunity to be heard if there is any kind of determination that the proposed merger might lead to public interest concerns. So that should guide the CCC on what considerations to take into effect and the analysis that they attach into it. So at least there will be elements of due process before they can determine that a merger should not be authorized in the event that it's going to have public interest considerations that outweigh its competitive effects.
Yeah, that's a good point. I mean, talking about then on due process for EAC and CEMAC, Cris, Hyacinthe, I mean, EAC obviously, I think, only started accepting mergers beginning of this month yet, so a lot unknown. But from what you've seen from the guidelines and the process, and the same question to both of you, the extent to which economic analysis and data is taken into account and evidence taken into account, but then also the ability to actually present that data, to have an opportunity to challenge evidence which is against you on a certain point. Maybe third parties have provided evidence. What is the sort of scope for that discussion, that debate, or that interrogation of the sort of underlying evidence as you envisage it or as you've experienced it in Hyacinthe case?
Okay, I'll start. First of all, the review or the assessment is we'll be looking into competition issues, obviously, but also public interest considerations. That one is categorically provided in the regulations, and the regulations go further to exclude a certain type of industries, for example, startups, areas around innovations, etc., etc. Those ones have been excluded. But the challenge is the same. What you're just saying right now. How will that be, interpreted by the commission or by the authority? It's another question. But again, if you look at the legal infrastructure, the regulations and the law, it's quite engaging. It empowers the commission to conduct interviews, to inquire, the public and the parties to the transaction. It is open-ended in terms of when the information can be provided, only that it will have an effect on the timeline. But we're looking at that and see how all these issues will be treated. Yeah, but the challenge, again, as you have said, is around definitions in the interpretations of public interest, what amount of public interest or otherwise.
Yeah. Hyacinthe, over to you.
Yes, Mike. In CEMAC, due process is typically followed because decisions are based either on evidence and theories of harm through a multi-phase review process. The process typically involves a detailed analysis. Typically involve detailed investigations, the collection and analysis of evidence, and then opportunities is given to the parties to submit their views and challenge the findings made by the regulator. With most mergers cleared either unconditionally or with condition after this process is complete. To give you more context in terms of the review process, typically what the commission does is that once a filing is received, the commission reaches out to the various competition authorities in the member states, even though they are not concerned or affected by the proposed transaction, so that they can give their opinion on the transaction. And Competition Act also make provision that member states can directly intervene in a major filing in the event of strategic sector, for example, in the defense sector, for example, or at I think it's defense concern. I think there is defense sector, energy, for example. Member states can intervene in the transaction and give their opinion as well. So this comes in line with the public interest issues. I will give you a more concrete example on a recent transaction I worked in recently. It was in the audiovisual sector. And then the commission was concerned with the large market share of one of the parties in the CEMAC region, and then requested the parties to provide some commitments that they would not infringe the competition law. Hello, Mike.
Hi, thanks. And just on, and thanks for that. And I think that's important. I mean, there's two observations I wanted to make. The one is where a member state doesn't have a national competition law regime in place. We heard from Cris that there's several in EAC that don't. And under CEMAC, there is still then an obligation to notify CEMAC, even if your national territory doesn't have a regime in place. Can you talk us very briefly around that,
yes.
that mechanism?
Yes. In CEMAC, there is a provision in the Competition Act that clearly states that when a member state doesn't have a competition law or a competition authority in place, the CEMAC Commission has the full power to review any transaction that shall be filed in that member state. More concretely, for example, in the CEMAC region, you have Equatorial Guinea, for example, which doesn't have a competition authority. So if you have a filing in Equatorial Guinea that triggers the threshold in that country and requires a notification, that notification has to be submitted to the CEMAC Commission. Yeah,
so we're talking about situations where there is a law and there are thresholds. It just isn't yet an active agency. Or
and likewise, when there is an agency, for example, but the agency is not functional, in the case of Cameroon, for example, actually the competition authority in Cameroon is not operational due to the lack of quorum at the level of the College of Members. So the competition authority in Cameroon, when it receives the filing, cannot validly make a decision. So in such a case, when you submit in Cameroon, they will refer you to submit your filing to the CEMAC Commission. Yeah, I had an experience recently with the competition authority in Cameroon. The filing was, the transaction was a national filing. The threshold in Cameroon was satisfied. And then we filed with the competition authority in Cameroon. And then when they responded saying that, okay, the file is admissible, but we cannot review this transaction because the authority cannot validly make a decision on that transaction. Please refer your case to the CEMAC Commission.
Fascinating, because there was a time I recall where Cameroon was also not sure if they're going to relinquish their jurisdiction to CEMAC, and it seems like now they're well, maybe not happy to, but certainly prepared to in these circumstances. Yeah,
but it's clearly on the regulation. they literally have no choice. Because same as with the EAC, the CEMAC has exclusive jurisdiction with regards to transaction of community dimension.
Yeah, no, exactly. Yeah. Just mindful of the time and any Q&A or any questions any of the audience want to ask. Cris, Mweshi, and Hyacinthe, I'm going to ask you to wrap up with any sort of last remarks that you have in respect of the respective regional agencies that you appear before, but also perhaps just to make a couple of remarks, if any, regarding your own national regulators who you appear before. Mweshi in your case, Zambia, Cris in Tanzania, Hyacinthe, you've just touched on Cameroon very fortuitously. So Cris, Mweshi, anything else any remarks you want to make before I think we're going to wrap things up?
Yeah.
I think I'll go first.
Okay, proceed.
Oh, sorry, Chris. So I think it's just worth highlighting that, building up on the discussion you just had with Hyacinthe on national competition authorities. Zambia, even before it domesticated the CCC regulations, had entered into MOUs and other agreements with them to recognize their jurisdiction. And we expect that this cooperation will only get strengthened now that we have domesticated the regulations, the Act, in our 2023 amendments. So we just expect that to carry on. And what I'm looking forward to seeing is how the provisions under the proposed amendments in relation to referral of notifications to national authorities is going to play out. Because if there's a determination by a national authority or the CCC itself that a proposed merger is going to have an effect of substantially preventing or lessening competition in a specific member state, that member state can either request for this CCC to refer the assessment to it or vice versa. So that is going to be an interesting interplay to see between the national regulators and the CCC, especially for those who don't recognize its jurisdiction. Thanks.
And also it'll be interesting to see whether the various national agencies are primarily focused in doing the competition assessment or primarily focused on trying to get that filing fee out of the system.
Absolutely.
Chris?
Yeah, my closing remarks will be that one, the major regime now, the major control regime in East Africa is now operational, and as I've said, it has exclusive jurisdiction. Moreover, most of the partner states have not domesticated. I understand that a few of the partners, local authorities or national authorities, have executed or have entered into MOUs with the East African Community Competition Authority. But if you look at those MOUs, still major control is left out. Okay, it only covers matters of restrictive trade practices, etc., market inquiries, etc. It is left out. So I think the advice that I can give now is that for the businesses, they just need to prepare themselves for multiple notifications, to avoid undesired consequences. That is number one. Number two, there's also an issue around Zanzibar. Zanzibar has its own national competition authority. It's called Zanzibar Fair Competition Authority. Moreover, Zanzibar is part of Tanzania, okay, and competition is not, or market regulation is not a union matter, and international affairs is a union matter. So in EAC discussions, the Tanzanian government will represent Zanzibar. Moreover, anything that is decided there that is not a union matter will not be binding Zanzibar. Okay, so as much as Zanzibar is part of East Africa, still you will not be able to say that as long as you filed at the regional level, you have complied with the requirements in Zanzibar. So you will still need to notify in Zanzibar. Third is on definition of change of control. We do not know what definition they will come up with. So it's something of interest, and I hope they get it right. So those are the few 5 points that I have. Yeah, and it's important to understand that the regime has an effect of suspending the merger until after. So when you're drafting those agreements, transactional agreements, you have to take that into into account. Those are my closing remarks, Mike.
Thank you very much, Cris. I think very useful remarks, and not great news for companies, knowing that they're going to have to do or consider a lot more notifications than perhaps currently on their radar. But I think the takeaway is that while there are some question marks, some uncertainties, those seem to be recognized by the agencies, and there seems to be a concerted effort to try and look for workarounds to ensure that the regimes don't stumble at the very first hurdle, and that we might not know what all the answers are right now. It doesn't seem like there's any glaring problem that would cause a filing to be held up for an ordinary long time, just because, as Hyacinthe pointed out in the Cameroon situation, there's just no quorum. So I think that's probably the encouraging takeaway. But I think certainly a new regime and a new approach to the African regimes is the order of the day. Mweshi, Cris, Hyacinthe, I'm going to wrap it up here. Thank you very much for your time and your insights. To those of you who have joined us, thank you for dialing in and listening. I hope it was of some use. Of course, if there's any questions that you had and didn't feel appropriate to raise on this session, please feel free to reach out to us. I'll put you in touch with whoever your questions directed at, or you can feel free to reach out to them directly, and I'm sure we'll be of assistance. So thank you from my side, and I hope to be in touch soon. Bye-bye, everyone.
Bye.
Bye-bye.
Thanks and bye.